Hello students, the topic for today's discussion is concept of secularism and freedom of religion under Indian Constitution. India is a secular country. Secularism means state's neutrality in the matter of religion. It means there is no official or sponsored religion of India like Sri Lanka, where Buddhism is the official religion. Pakistan is having Islam as a national religion. Such sponsorship of religion is not available in India. Indian Constitution is the supreme law of land. It determines the rights, duties, liabilities, power of the person and institutions. Part 3 of Indian Constitution is pivotal sector under Indian Constitution. Secularism. Concept of secularism is not defined anywhere under Indian law. It is expedient to know the concept of secularism in India. Secularism in its literal sense means complete neutrality of state in the matter of religion. The world is of course not consistently marked out. Even so often, secularism refers to set of principles concerning God's linkage or its absence. The process of secularization has to be viewed in the context of separation of state from religion. But one has also to remember that secularization came to be an important handmaid of entire process of modernization. Secularism has been thought of in various ways, such as it is antithesis to religion and its inconsistency with rationality, materialism, individualism, etc. The term secular state is commonly used in present day India to describe the relationship that exists or which ought to exist between these states. Secularism has been regarded as sine qua non of economic development, industrialization and an overall development in favor of rationality. Constitutional provisions. The Constitution of India is most elaborate constitution of the world. It consists of various pious rights for her protection and welfare of citizens in India. The word secular under Indian Constitution is very crucial phrase used by person who doesn't want India as fundamentalist state regarding religious matters. We have not intentionally adopted a particular religion as national or as official religion of the state to adhere the concept of secular state. The concept of secular state is borrowed from Western countries. The secularism is true secularism because they used to adopt complete neutrality in the matter of religion and vice versa. Preamble of Indian Constitution. Preamble of Indian Constitution is key to read the minds of the maker of Indian Constitution. By 42nd Amendment Act 1976, word secular was added and thereby India became secular country. Fundamental right of Indian Constitution, Article 19, Clause 1, Subclause A of Indian Constitution. Out of one of the 6 golden freedoms, freedom of speech and expression is very important freedom. Freedom of religion is also a part and parcel of freedom of speech and expression. Since the dawn of human civilization, we have been seeking justice, liberty and equality. Especially liberty is considered a milestone in a civilized society. Man is a rational animal. He thinks, he imagines, he believes. So, for his growth, he needs liberty. For expressing himself, he needs freedom of expression, as many people believe in religion of supernatural powers, so they need liberty of faith and belief for satisfying their emotions. In a democratic society, for participation of people as a democracy is of people, by the people and for the people, they need to express their views and they should be free to do that. Article 21 of the Indian Constitution. It is the duty of the state to protect life of people and for that purpose the incidental right of persons shall be protected as provided in Article 25 of the Indian Constitution. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Freedom of conscience and free profession, practice and propagation of religion subject to public order, morality and health and to other provisions of this part, all persons are equally entitled to freedom or conscience and to freely profess, practice and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting an economic, financial, political or other secular activity which may be associated with religious practice, providing for social welfare and reform, or throwing open of Hindu religious institution of public character to all classes and Hindu sections of Hindus. Explanation 1. The wearing and carrying of kirpan shall be deemed to be included in the profession of Sikh religion. Explanation 2. In subclause B of clause 2, the reference to Hindus shall be construed as including a reference to professing the Sikh, Jain or Buddhist religion, and the reference to Hindu religious institution shall be construed accordingly. Liberty of belief, faith and worship, viz. Freedom of religion and conscience. As the preamble of Indian Constitution guarantees liberty of belief, faith, worship, so Article 25 of the Constitution gives freedom of conscience, free profession, practice and propagation of religion since inception of human beings on earth has certain basic needs which is not only biological and intellectual needs but also have psychological needs. Religion, viz. Faith, belief and worship are such kind of need, and hence it was equally necessary to provide liberty of belief, faith and worship along with freedom of speech and expression. But personal belief, faith and worship shall not create law and order situation or shall not violate fundamental rights of others. Thus, the purview of liberty is very wide and we need to view all its aspects in detail so that we can search for exactly what kind of liberty we have. What are the reasonable restrictions on it? Whether these restrictions are really in the interest of social harmony and national security, whether there is a misuse of restriction, and what reforms we need in regard of liberty along with its restriction. A right without restriction is in vain, so there should be reasonable restriction on liberties of individual. Proper restriction can be proved as better safeguard for freedom of persons. Religious freedom is most sacred freedom through which person can exercise liberty. It is the duty of the state to mention law and order situation in the society. If state is encountering frequent religious or communal rights and violence, then state is duty bound to mention peace so that persons can exercise their freedom of religion. Article 25 is providing freedom to individual as well as freedom to religious denomination as well as religious institutes. In Church of Goa in India versus KKR Majestic Colony Welfare Association, the Supreme Court was hearing a public interest litigation regarding use of voice amplifier, beating of drums. The court held that all these things are not mentioned anywhere in any religion, hence all such activities creating nuisance and hence use of loudspeakers is prohibited or treated as violation of fundamental right. Freedom to manage religious affairs. Subject to public order, morality and health, every religious denomination or any section thereof shall have right to establish and maintain institution for religious and charitable purpose, to manage its own affair in matter of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. The religious endowment are also artificial personalities in the eye of law. It can be exercised all fundamental and other constitutional and other statutory right as a matter of right. This article provides an opportunity to own property in the name of particular religion denominations. This is supplementary and complementary freedom enshrined under Article 25 of Indian Constitution. It is an extension of what is substantially provided under Article 25. While exercising the freedom of profess, practice and propagate religion, it requires certain freedom to religious denomination and institution. Example, religious education is required to impart by particular community, then it requires infrastructure and manpower, so it will be the responsibility of a religious institution to acquire the movable and immovable property in favor of religious institution. Without a property, any religious institution cannot come into existence. It requires a state's active support. This help is given by Article 26 of the Indian Constitution. Article 26 confers freedom as to manage religious affairs. It means religious denomination can handle all religious subjects and state will not interfere unless there is problem on the ground of public order, morality and health. Indian judiciary has played a vital role in shaping religious and denominations freedom to manage affair of a religion. In Acharya Jagdishwar Anand versus Commissioner of Police, Calcutta Apex Court of India held that a religion and religious denomination are different from each other and sometimes tenets play very important. Still in this case, Supreme Court of India refused to recognize Anand Margis as a religious denomination and it was held as part and parcel of Hindu religion. In case of Narendra versus State of Gujarat, Apex Court was encountered with a question whether religious endowment property can be acquired. Procedure followed under Article 31A, Clause 1, Subclause A. The court replied in affirmative and held that the property of a religious institution can be acquired for agrarian reforms. Apex Court also held that state sealing laws are also applicable to property of religious denomination and surplus land can be acquired and may be distributed among landless persons. Freedom as to payment of taxes for promotion of any particular religion. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. The mentioned article of Indian Constitution give freedom to all persons from payment of taxes. The state is also barred from collection of such taxes from public at large. The person may judicially decide the taxes which are ultimately going to expend for promotion or maintenance for a particular religion. In Prafulla Garadia versus Union of India, Apex Court of India cleared its stance on compulsion on payment of taxes for the welfare or propagation of any religion. It also stated that Article 27 attracted only when any law which is levied and collected tax is going on utilized for specified religion. It means person can decide the payment of taxes to any religion. It also includes religion of its own. There are various trust acts passed throughout India for some charitable purpose. If such law is passed by state, whether it will heed by Article 27 of Indian Constitution. The Supreme Court of India had cleared in Mahant Moti Das versus SP Sai and held fee imposed by Bihar state under Bihar Hindu Religious Act, where a fee was collected from person and it was challenged as infringement of fundamental right. But Apex Court of India held that fees collected under the act is not a tax and hence not violative of Article 27 of Indian Constitution. Freedom as to attendance at religious instruction or religious worship in certain educational institution. No religious instruction shall be provided in any educational institution wholly maintained out of state's fund. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under the endowment or trust which requires that religious instruction shall be imparted in such institution. No person attending any educational institution recognized by state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such situation or attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or if such person is a minor, his guardian has given his consent thereto. This article of Indian Constitution provides ample freedom regarding attendance of religious instructions or religious worship in certain educational institution. If any education institution is imparting religious and if same is running out of the funds of state consolidate fund of that state, then religious instructions and religious worship is totally banned. But any educational institution is established under religious endowment or trust, then it may impart religious instruction and worship. In case of Aruna Roy versus Union of India, Supreme Court of India held that if philosophy of all religion is teaches as a part of comparative study, then it is not hit by Article 28 of Indian Constitution. Protection of interest of minorities. Any section of citizen residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by state or receiving aid out of state funds on the ground only of religion, race, caste, language or any of them. Right of minorities to establish and administer educational institution. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. In making any law providing for compulsory acquisition of any property of any educational institution and established, administered by minority referred to in clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under the clause. The state shall not, in granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. The minorities, whether religious or linguistic minorities, can establish educational institution of their choice, and most important, they can administer such educational institutions. Uniform Civil Code for the citizen. The state shall endeavour to secure for all the citizens uniform civil code throughout the territory of India. It was a directive to the state to apply uniform civil code to all Indians, so that all will be administered by the same law regarding marriage, divorce, maintenance and guardianship. It was expected that personal religious faith and belief and modes of worship shall not interfere in the uniform matter of religion. In many cases, Apex Court of India directed the state to legislate on Article 44 of the Indian Constitution. After 65 years of Indian Republic, still we are waiting for a masterpiece of legislation from our highest legislature, so that all India can be treated alike. Justice Kuldeep Singh has opined and directed to state to have a fresh look at Article 44 of Indian Constitution. The court was also of view that this is the correct time to enact a common law for all Indians. In the judgment of Supreme Court of India held as when Constitution was framed with secularism as its ideal and goal, the consensus and conviction to be one socially found its expression in Article 44 of the Constitution. But religious freedom, the basic foundation of secularism, was granted by Article 25 to 28 of the Constitution. Article 25 is very widely worded. It guarantees all persons not only freedom of conscience, but the right to profess, practice and propagate religion. What is religion? The court has expanded religious liberty in its various phases guaranteed by Constitution and extended to its practice and even external overt act of the individual. Religion is more than mere matter of faith. The Constitution, by guaranteeing freedom of conscience, ensured inner aspect of a religious belief and external expression of it were protected by granting right to freely practice and propagate religion. Reading and reciting holy scriptures, for instance, Ramayana or Quran or Bible or Guru Granth Sahib, is as much as a part of religion as offering food to deity by a Hindu or bathing the idol or dressing him and going to temple, mosque, church or gurdwara. Marriage, inheritance, divorce, conversion are as much religious in nature and content as any other belief or faith. Going around the 7 rounds or giving consent before Qazi are as much matter of faith and conscience as the worship itself. When a Hindu become convert by reciting Kalma or a Muslim become a Hindu by reciting certain mantras, it is a matter of belief and conscience. Some of these practices observed by member of one religion may appear to be excessive and even vocative of human right to member of another. But these are matters of faith, reason and logic have little role to play. The sentiments and emotions have to be cooled and tempered by sincere efforts. But today, there is no Raja Ram Mohan Roy who single-handed brought about that atmosphere which paved the way for Sati abolition. Nor is a statesman of the stature of Pandit Nehru who could pilot through successfully the Hindu Succession Act and Hindu Marriage Act, revolutionizing the customary Hindu law. The desirability of uniform code can hardly be doubled, but it can be conquered only when social climate is properly built up by elite of society, statesmen among the leader who instead of gaining personal mileage rise above and awake the masses to accept the change. Enactment of Uniform Civil Code is superhuman task before Indian legislature. It is difficult to bring all faith under single umbrella. The religion and personal belief and faith are most sensitive issue because they are contradictory, religious rites and rituals. If all these are to bring under legislation, hence after 65 years of evidence, we are unable to legislate one such important issue. The ideologies of different parties are responsible for such apathy and appeasement policy of towards community. If we are a true secular country, then there is no problem in enactment of uniform civil code for all citizens. It is also a constitutional mandate which is to be followed, but no political party, including all major parties in India, failed to follow the intention of legislature. The Supreme Court in Sarla Mudgal's case categorically directed to centre to take initiative and bring all persons at equal footing in matter of marriage, divorce, succession and guardianship. Role of Supreme Court of India in shaping religious freedom and secularism. Judiciary is the third and most important organ of the state, which is so vital and pivotal that one cannot imagine the concept of democracy in existence. A constitution cannot secure fundamental rights by merely making pious declarations. To make the promises of fundamental rights enforceable, a measure of judicial review is essential and indispensable. The body is supreme adjudicatory authority in democratic country. It is the duty of body to solve the dispute between the and amongst the parties. Adjudication is primary function of judiciary. Under Indian federalism, central-state relationship is also governed by judicial pronouncement. We will find thousands of decisions which regulate the behavior of the state. The present-day judicial system in India is quite complicated and not easy to be explained in brief in a type of work as the present one is. Indian Supreme Court is most powerful court as compared to any apex court situated in the world. In 2014, Supreme Court delivered a judgment and held that Badwe and Utpat can't priestship as a matter of right because economic administration of temple is purely secular activity and state is empowered to regulate the day-to-day activity of temple. The trust in 2014 advertised in news as to vacancies and 8 persons were appointed as employees of the state government. The most important thing is that there are 2 females out of 8 posts of priests of the temple. This is one of the instances of the interference of judiciary in the matter of religion. Concluding the topic, the judicial justice is the highest kind of justice to be done with aggrieved parties. Judiciary is the protector, provider and investigator in the modern world. It is the duty of the state to mention law and order situation in the society and to control the behavior of individual. Liberty play very important role in the inner and outer personality of person. More the liberty of individual, more the effective out of individual skill. Freedom of religion is one of such liberty. Religion is a personal matter and hence the state shall not interfere in the personal matters of religion. The Indian state has followed this principle with great caution. There is plethora of instances where it becomes expedient to interfere in the religious issues. In this way, it is concluded that the concept of freedom of religion and secularism enshrined under Article 25 of Indian Constitution are very dynamic concepts. The Supreme Court of India played a very significant role. If we observe the judgments of the apex court from 1950 onwards, there is tremendous change in the philosophy. It is reflected in various judicial decisions. Since from the Shirmat case to Nikhil-San case, the Supreme Court of India has become really supreme in protection of freedom of religion granted under Article 25 of Indian Constitution. Freedom of religion is subject to the rights of other and Supreme Court of India played San Kya Non rule. Secularism is a phrase used under Indian Constitution but undefined or not clearly defined as fit to Indian democracy. Hence, it is a dire need of time to define this concept. I hope this lecture is useful for you. Thank you and have a nice day.